It's not a letter any for me. So today we are going to have Ms. Fincher of J.K. Fincher, Law LLC. We are going to have her talk to us about something I know I'm very interested in. I feel like you never know too much about the contracts and legal talk. So, Ms. Jennifer, if you go ahead and take it away.
Right, thank you so much. Thanks for having me here today. Always fun to come to get outside of the office. I tend to walk in and not and eat lunch, standing over the sink between closings, and then and leave for the day, and that's about it. So it's nice to see the outside world, especially on a sunny day. So I have prepared some things for you guys to talk about the contract, to talk about how the contract and what you do intersects with the closing process, how we get things done. Please ask questions along the way. Just throw up a hand or shout them out, because this is about making sure that you get the information from this that you want. So first, we're just going to start with something that seems really basic. Are you turning our AC now? Yeah, I'm gonna turn it off. Like, okay, that's what you're hearing out. I'll go. You're like shivering. No? Alright. So first of all, just starting with the very simplest thing, your buyer. It is really, really important to make sure that you know the legal name of your buyer. So I can't tell you how often this comes up. From the standpoint of a lender, so let's just assume we've got a buyer in a finance transaction. They walk into closing. We have their closing package from their lender already, and it has Suzanne Smith on that closing package, right? And we ask for her IDs, and Suzanne hands us an ID, and it has Suzanne Kelly. You say, "Hey, Suzanne, did you change your name?" So then we get into this whole thing about, everyone seems to do all the things at once, right? They get married, they change the name, they buy a house. And if some of those things are off between what their photo ID says, what their legal name is with Social Security Administration, who they told you they are, because they might be Susie Smith to you, and they might be Suzanne Kelly or Suzanne Smith to the lender. So then we've got to figure out who they really are. Sometimes it's a really easy fix, right? And we can quickly, in a matter of 20 or 30 minutes, confirm what the legal name is, get a revised closing package from the lender, and keep rolling. I've had a handful of situations though where it meant it wasn't closing that day at all, and it was going to take 3 or 4 business days to get it straight because that other name needed to be run. So just to be really clear about this, when you talk to your buyers, ask them their legal name. Some folks will need you to go a little bit further on that. So we're not just asking what's on their photo ID, because you can walk into most DMVs and give them supporting information and get an ID or a driver's license, almost any name, right? I mean, again, you've got to have supporting documentation, but it doesn't necessarily match your Social Security card. And that Social Security card is what controls. That is your legal name. Okay. So I would just put that out there, especially in a situation if you know that you're working with a couple and they've recently gotten married, you may want to go ahead and ask the question. Is she or he changing their name? Where in that process are they at? Because what happens is, as you know, they've got to submit that information to the Social Security Administration to change the name. Then they've got to just go to DMV or to a passport office to get their photo IDs changed. We have to have a government issued identification to fill out Matrix Act forms. As you probably also know, it now takes several months typically to get an appointment with DMV. So you just want to make sure that your folks understand that. There are certainly some places that you can walk in for a photo ID and get that done, but just make sure they understand. They're so excited in the process, they're not thinking about closing day and needing to present a photo ID that actually has the legal name. The only other thing I'll say about that is make sure that their photo ID is not expired. I've had tons of those as well over the years. And it's super easy. In most states, you can renew a driver's license online. And honestly, as long as they have that photo ID and they have that slip that they can print off that says I've renewed and my ID is on the way now, that's great. We can proctor those documents together to go closing. All right.
Now, is it the same, I know it's a marriage in, with the name change, but on the divorcing, when somebody has been married and they get divorced, maybe, not saying that this happens a lot, but somewhere while they're under contract, but they have the ID, the social security card with their married name on there, does that pass or does that end up being like a flag?
Yeah, so it depends is the short answer. In a divorce judgment, the spouse has the option to amend the pleadings. They can keep that married name, or there can be part of that accomplishes them resuming a maiden name. So it would be a court order to resolve that piece. That's not of utmost importance to us. We have to have a photo ID that has whatever the legal name is in order to notarize. Okay, so that's really the important thing to ask about. The other thing that we deal with week in and week out is marital interest.
I was gonna say, yes. Oh my God. Yes.
So whoever created the phrase "one to buy and two to sell," I like to, in a nice way, strangle them, because I think it can be true, but it's not necessarily true, and I think that's really been put out there. I think a lot of the agents kind of bank on that, and that's really not entirely accurate. So let's talk about that, right? And you may have some closings that you've been through where this came up, or you may have questions on this as well. So if a person in North Carolina is married, we need to know that. Okay, so our office sends out buyer information sheets to our clients in advance, and one of the questions on that is, what is your marital status? What also often happens is if someone is happily married, they are generally happy to tell us about their spouse. If they are separated, they are not, right? So part of the closing paperwork as well, so they may mark on their buyer information sheet that happens early in the process, like no spouse, right? They're like single. They're not single, right? They're not actually single. In the closing room, they have to sign an affidavit swearing to their marital status, and so it becomes a little bit more important, right? So I can't tell you how many over the years we're sitting at the closing table. You, the agent, have only met that person sitting at the closing table. They've never said anything about their spouse, whether they're separated or together, right? Because particularly in our community, may have a spouse that's employed, they may not have moved here yet, all sorts of things, right? Whether they're separated or happy as they can be together, they need to be involved, and at a minimum, there has to be a conversation. So we have multiple ways to deal with that. When a buyer is married and they are paying cash for property, that's fine. We can close all day long. But we're going to list their marital status on the deed. We do that because it changes what needs to happen when they sell that property. It also makes it a little easier on future title searchers to figure out what's going on with the title to that property. If they are getting financing, this is where it gets fun, right? So first of all, I think it's a conversation that needs to happen, because if spouses are going to take title together, let's say very, very standard scenario, our buyer is getting a VA loan or using their entitlements, they're buying the house, maybe spouse is not here yet, right? Spouse is in a different state with the kids. They still need to have I believe they still need to be able to understand that if they want to own that property by themselves, they can, if we can get through some other stuff. But there's a great benefit as a married couple to owning property together. We call it tenancy by the entirety, which is not a legal phrase you necessarily need to know. It is assumed if a married couple takes title to property, it insulates it against certain types of judgments and liens. So, for example, if just wife gets sued and someone is successful in getting a judgment against her, but husband and wife own that property together, that judgment is not attached to the property. Okay, so that's an important one. It's a little sticky on tax issues with IRS. IRS is find a way to get there. But the other really important thing is that when a married couple owns property together and one of them passes away, the property immediately goes to that surviving spouse. If both spouses are not on the deed, that is not the case. I can't tell you how many situations where someone passes on, they didn't have a will, and so now we're back to intestacy statutes. And I don't want to get too far down the wormhole on estate administration and that kind of thing, but I do want to just give you this tidbit. If someone dies in North Carolina without a will, then these intestacy statutes, which is just a word they're intestate instead of testate. Testate meaning I have a will, intestate meaning I don't. It means that if they are married and they have children, both spouse and children inherit property. If those children are not over the age of 18, you have to go through several different processes in the court system to get approval to sell that house. You have to have a guardian appointed for each child who won't be mom necessarily, could be, or dad. But it's a guardian of the estate of the minor child, meaning the property that minor child owns. Then you also have to ask for permission to sell the property. You have to show why you're selling it, that it benefits the child, and that it's being sold for fair market value, just to name a few of the things that we're typically presenting to the court. That process obviously does not happen overnight. It gets even trickier if we have if that freaking out. I our house age, and so she did the VA, and I think to be honest, still her age, so it's just under 10, and I literally just texted him like, please try not to die today until we figure out what's going on. I speak because I'm gonna call you and be like, what's now this out there? Must be fair. Yeah, so that's the sort of attitude, right? So yes, so you can answer all those. But so that's why I say there at least needs to be a conversation. That's, folks just assume it goes to spouse, and that's not the case, right? So the other part of that is that if they do want to own that property by themselves, and let's just assume the easiest they're separated, right? Then there are a couple of ways we can proceed without the spouse being involved. If they have a prenuptial agreement that contains certain language that says they can buy and sell as though they are a single person, great. But that prenuptial agreement has to be recorded, which puts all of their business in the public record. Okay. Same with a separation agreement. They have a separation agreement that has that language. That's fine, you can proceed, but it has to be recorded. So any of their personal information about who's paying what, who gets what, all of that then becomes public. What we sometimes see, that language is called free trader language. And in very simple summary says that if a married couple have a free trader agreement, they may acquire and sell property as though they are single, right? So they do not need joinder of the other spouse. That free trader agreement has to be recorded. Right, so all these things, I keep saying that to really hammer home, it has to be a part of the chain of title. Because 6 years from now, when they get ready to sell that property, somebody's going to be looking to say, why didn't the spouse sign? Right? Because that would be a title. We can, of course, get a quitclaim deed from spouse, so they can quitclaim their marital interest in the property. And then the last option, at least for purposes of today, is what's called the doctrine of instantaneous season. It's a whole lot of legal mumbo jumbo. And I love the ways that it gets spelled in emails back to me when people are trying to figure out what it is.
Can you say your doctors are in,
Instantaneous season.
This is real estate school coming up. They used to teach this.
Yeah.
17, however many years, however long I've been licensed. They used to teach us all of this in real estate school. We were all like,
You're like, what?
I have no idea, but what is this right? I all this.
You know, it's one of those things that seems like so bizarre.
It is.
But it's so much more sensitive than you know, let's say still.
Yeah.
Yeah.
And that's how you see how to do the hugs.
I just want to like throw something when I hear that for
Yeah.
yeah. So instantaneous season, again, really simplified, just says that a person using their own money or financing can purchase property in their own name without joinder of the spouse, meaning participation of the spouse. But the lender has to approve it. And not all lenders are okay with this doctrine. Okay. The other thing that instantaneous season requires us to do is to modify some of the documents. You just have to add some words basically to the deed of trust. A lot of lenders are not okay with us modifying their documents. We have to get their approval to do so. The third part of that, and why I always hammer, we need to have a conversation with the borrower. Like, let's not just fix it. Let's make sure they know what we're doing. Is that it doesn't do a darn thing for marital interest. So let's say Matt and I'm going to use Susie since we're using Susie. Matt and Susie are separated. They're not speaking to each other, so Matt's really not fired up about telling her that he's buying a house, right? But when Matt and Susie get divorced in another 6 months, guess what? He just acquired property during the marriage that she has supposed marital interest in. And if he doesn't get her to sign a quitclaim deed now, he either needs to deal with it in court in an equitable distribution order, which he may not be filing fees for ED. Or he's gonna have to get her to sign when he sells that property. That also comes up quite a bit. So it's again 3, 4, 5 years down the road. He was married at the time, she didn't sign, and the first answer I normally get is I don't know where she is. And then we typically are able to find that person when I tell them they can't close.
What's the difference between that and free trade agreement that they? So I know I have a client who was married.
Yep.
Buying a house with her boyfriend and yeah. And I didn't know that she was married. We closed up and we didn't know that she it came up toward the sale end. And I was like, "Whoa, what? You're married?" Like I was like, "Wait, what? You buy his fiance?" And so we have to track him down. And I thought he signed a free trader agreement or something like that.
Is general in nature. In other words, it can cover any property. Okay. So it's a quitclaim deed is specific to the property name.
Right.
It's not that up. Yeah. Right. So either or.
Okay.
But yeah, just one or the other really.
I want to make sure that I was. If that happens again, it seems to happen to me a lot.
It happens. I mean, it happens all the time.
Yeah.
I've had a lot of agents who get surprised at closing.
Yeah.
You're being a spouse.
So you're literally buying for this person, and so I figured that all your other stuff is taken care of. And then she's like, "I'm married," and I'm like, "But not today." Like, no. And okay, where's he? What are we doing? You know, it's so wild. It was great. I'm saying believe they were present.
I don't know if you remember there was a scenario where I had asked you about a guy who could find his wife, like they hadn't spoken and they were still legally married, but he told me that he could not get in touch with her for 10 years.
Right.
And so I know in that scenario, when you do these different options, do both of them have to sign it?
So on the seller side, something has to happen here, right? So if we can't, so on the seller side, we can't, we can't waive it, we can't get title insurance over it, we just don't have an option. So that the person in that situation is either going to have to file appropriate pleadings within their divorce, depending on if they ever got divorced. I mean, in some situations like that, a spouse leaves and they just never finalize. So there could be motions filed within a divorce proceeding to deal with this. Another option is what's called a petition to partition, which is again a court proceeding where we own property together, not just for married couples, but for anyone who owns property together, and they don't agree on what to do with it. In that situation, she or he that's gone somewhere else may not even know. But it's a way to, without going down that wormhole, it's a way to deal with their interests as well that results in court orders, which I hope is. All right.
This is right at your eye level and it's driving.
I know that.
We're like, you like side.
Take your own name.
Like I can't.
That's funny. All right, so now let's flip. Let's talk about the seller side. All right. So we've talked about a seller if they're married, separated, divorced, married, right? If they're married, spouse signs. If they're separated, spouse signs. If they are divorced, it depends, right? So let's go a little bit further down that. Let's say that again, we're using Matt and Susie all day today. Matt and Susie are divorced. Susie has remarried. And Susie has married a gentleman named Robert. So Matt and Susie were both on title. They both took title to the property. They're still on title to the property. They both have a son, and Susie's new husband has a son. Right? So any spouses have a son. Yeah, all of that would be like,
That's
all
fair.
right.
Yeah, speaking of personal situation.
Yeah. I do want to. We're going to talk a little bit about death. And we'll start with death of a spouse. So if two folks, again, if a married couple start there, own property together and one passes, then their interest immediately went to the other, right? So we're gonna need some information about the death of that spouse so that we can put that information in the deed. Really important for purposes of, particularly here in Cumberland County, the tax office updating the tax record. They will not, unless that information is available in Cumberland County records. So for example, a person died here, there's a mistake filed here, it's all those things here. But if we, I call it burying it in the deed, if we put that this person died on this date, living in Cumberland County, North Carolina, when we give them information, they will take that information for updating the tax record. Tax record becomes important to people later. I know you guys are like updating tax records to look at who owns property. So it is important that you try to keep that as clean as you can. So we work with the tax office quite a bit anytime they have questions on something we reported.
Can I ask you a question? Sure. My first listing has traumatized me because okay, it was a situation. It was a situation that still doesn't make sense to me. But okay, the owner of the home passed away, suicide. They weren't married when they purchased it. They got married, so the spouse wasn't on title. Yep. And so it ended up being where I had to literally work with spouse and the deceased owner's parents. Does that make sense? It didn't make sense to me, but apparently, like we had to split everything between him and the parents. So down to the problem.
It'd be interesting to see the deed and exactly how it was titled, but again, kicking back to that intestacy statute that I mentioned.
Mm-hmm.
So if someone dies and they're married and children, it goes to spouse and children. If no spouse, no children, then it picks up the parents. If parents are not surviving, then we go to siblings. So I'm guessing that somewhere in that mix. Okay. I don't know. I mean, but that would make sense if you said they were divorced?
No,
No, they had gotten
they
married.
were still married when the owner killed her. So we thought that they were just all automatically go to my spouse,
Right.
but for some reason the parents got moved in, which made, I had to work like twice as hard on everything.
Sure, yeah, normally. I'd be interested to see it.
I it doesn't make sense to me
Yeah.
years later.
I get when we get to parents, test some statutes, but not with surviving spouse, so I have to.
Just always heard me the wrong way. I didn't feel like something.
Yeah. Alright. So death in general, we'll get out of the married couples here for a few minutes. I get a lot of phone calls from agents saying, who do I put on the contract? Right? This woman owned this property. She died 6 months ago. Her kids want to sell it, right? Or something like that. So first and foremost, if someone owns property and they pass away and we are selling their property within 2 years of the date of their death, there has to be an estate plan. Period. That is statutory. It is something that's required to clear title, right? If so when you guys are talking to folks like, hey, this is moms or this is dads or whatever, right? You need to look at the deed then. If they have if it's been more than 2 years since the passing of the person that owns the property, then we can get, there are other ways we can deal with it. We don't necessarily have to open the estate file. Sometimes we do need to create and record what are called heirship affidavits, which is someone who knew the person who passed away, they knew their family structure, and they're willing to attest to who their surviving heirs are. So that again, we can put something on record saying, I knew her when she died, she had 2 children, these are their names, right? And then that's something that helps us build that from a title insurance standpoint on having enough to go on so that children can sell the property. If we're in a situation where an estate file has to be opened, it is going to take a couple of months. I no longer do estate administration, so I refer that out quite a bit. To some other attorneys here in town that I'm sure you all know. They don't have to finish the estate filing, but they have to get to a certain point where they run the notice to creditors. Everyone, of course, always wants to know, well, when can this close? And they want to know a number of days or weeks. There's no great answer to that, right? It depends on how quickly people fill out paperwork, how quickly they get an appointment with the clerk's office, how quickly it gets processed, approved, and all the back and forth and everything that they have to do. But about the quickest I've ever seen it done, I would say, is, I don't know, maybe 6 weeks or 2 months. Maybe that's quick. So I'm just gonna put that information out there because if you ask that question at the listing stage, then you've got a little bit more time, right? Like a couple weeks or even more, so that we can get them to someone who can help them with it. And they don't have to have an attorney to do estate administration. Estate administration is form driven. There are forms that the state puts out so that folks can handle that on their own. Some folks just get overwhelmed in that process and need help. So
we can choose like when you're at on the paper, like there's 2 people on the lead and you don't look at one, there's kind of like when you know that seems confused as how that would not be brought out.
yeah, I think it's most often where I see the oops is where, you know, a child of someone or some relative of someone comes and says, I want to list this house, and you know, you're talking to Timothy, right? And you pull it up and it has whomever on title, right? Not Timothy. Then yeah, it should trigger a question of, all right, well, who is this person?
Yeah.
I think sometimes Timothy really believes he has authority to sell. He either, I'll tell you a really common thing. Timothy has POA for his mother that passed. POA is ineffective after death.
Yeah.
Right?
Yeah.
But Timothy doesn't realize that. So he thinks because he has POA, he's handling everything for his mom before she passed, then he can also sell the house. So I've seen that situation. And sometimes folks just don't realize that probably the most common thing is Timothy has always handled everything for mom. She died, didn't own her terribly much. She had the home and the car and that's it. And so he really thinks, why do I need to file an estate? Right? We're not dealing with, I think there's a misconception that estate filing is for people with a lot of wealth. For the word estate, I think in many people's brains means wealth.
Brand.
And it's, yeah, and so it's not, it's a leading thing. So the folks just don't want it.
Question for you. I know a family who, passed, that's long ago. She had 3 adult children. 2 of them, you know where they are. Third, no one knows where she is. You know, I don't believe that she knows her mom passed. Nobody's been able to contact her. Her mom also had siblings, and they have a house. Like, how do they go about selling this?
They would have to do that petition for partition. That would probably do them.
Does any potential heir play a factor in that?
Yeah, I mean, the missing heir, we've got to do something with that interest, right? So, and listen, I mean, we have helped people they're not in contact with, whether it's a spouse or a team or whatever. On social media, I've suggested to some clients that they hire a private investigator to do a little digging. Or ultimately, the petition to partition is a way to get a court order to sell it. So yeah, there's no getting around it really.
So not putting down too much of a rabbit hole, but if you can able to still sell and if it's like 3 years, let's say, and you can't find the third one, then they make $150,000 on property. 50 goes to this one, 50 goes to this one, and 50 stays in, an escrow account, which Sunday if they ever found that person.
Not without a court order, because somebody's got to sign for that third person, and yeah, that's the issue.
If they don't find a person, is there some way to find that interest though? Split it just between the other 2?
Not without a court order.
So the judge would decide, you've done enough investigative digging, this person has no.
And they'll decide, whether or not the property should be sold, what should happen to the proceeds. Petition to partition is used in a lot of different situations where folks own property together and typically can't agree on what to do with it, right? They might be arguing over proceeds, I've seen in a lot of situations where another big misconception is that as, let's say, actually, I'll give you a great example of something I had. So mom and dad purchased property in, let's say, 1912 or something like that. They passed away, they had several children. Those children had several children. So on and so forth, right? So we get through 3 or 4 generations. The misconception out there is that that interest in the property remains with the survivors at each level. That is not the case. Interest splits as many times as we split, right? So if mom and dad had 2 children, those 2 children each had 2 children. All of those people are inheriting as we go. So we did a title search for a woman one time. We got it up to 40 some heirs, many of whom would likely not know they owned a portion of this property. Unfortunately, she didn't know where many of them were, and the cost and the time involved in trying to track them all down, get them to sign a deed. Unfortunately, sometimes when people don't know they have interest in property and then they find out that they do, they want compensation for that. Even though she'd been maintaining the property and paying tax insurance for many years. So there was no great fix for it, right? But a petition to partition, in a situation like that, court will rule on if this person has been maintaining the property, they have expenses that should have been shared by all of these different people who technically have ownership interest in the property, then she should be reimbursed for that, right? And then the proceeds from that sale should be apportioned to the interest that they each have, but so that again, that petition of, I hate to keep going back to that, but that's part of why we use that. Because you can't force someone to sign to sell product, right? Except if you own something together, then there's a process by which you can get court orders.
What's the best way to get around having a will very detailed out what it's supposed to be?
I do estate planning as well, work with a ton of clients. And certainly, wills are great, but I did a lot of deed work with people. There's so much that we can do in deeds. We do it for multiple purposes. Some of that's just so that property automatically passes to whomever they intend at their death without the need for probate, without anything else having to happen. So just like in the married couple example that we kind of started with, where property immediately passes to the spouse at death, we can also accomplish that same thing to anybody else, right? It doesn't have to be children, it doesn't have to be a relative, it can be your best friend, it can be a charity, it can be whatever. But we can accomplish that same thing by deed work, right? There are different types of deeds that we do. Some of those take effect now, meaning that you want to add your daughter to your property. She's going to own it with you now. You're going to add right of survivorship language so that it immediately goes to the other of you, one of you passing. There's something called a ladybird deed in North Carolina, which essentially it's a certain formatted deed with certain language in it that only takes effect when you pass away, right? So for right now, you own that property by yourself, but when you die, it goes to whoever you put in that. We use life estates. I could rattle off the whole audience, right? But so a lot of what I work with in estate planning, without getting too far off topic here, is sometimes we do some deed work. There can also be some benefits to avoiding Medicaid liens and doing some deed work. And we work on other things outside of the will so that we can avoid probate on other assets as well. So lots of options, but just work the conversation.
Yeah.
So I have a question. Sure. So it's a pleasure talking to me. So I'm married and have a house. My husband passed. And so the house is now mine. He did not have a living. So it's mine and mine show. So you said
Were both you and he on deed?
yes.
Then it's just yours.
It's just
Yes.
okay. So
Like,
okay. So and we have a good relationship.
Sure.
Yeah.
But then, okay, so his parents, they had deeded their home to us. And so now that he has passed, it's mine.
As long as both of you were on the deed. Yes.
Yes.
Yes. But my answer would be different if it was just his name on that.
So if I were to sell that property, there would be no issues.
Just you signing again, I don't know how long it's been, and I'm sorry. But we would just need to get some information about his passing to include that in the deed to show that you're the only one signing. Okay. Yeah, of course. Okay, enough talk about it.
Yeah.
That.
Yeah, that's great.
It's from that. I'll start paper. All right, let's talk about I want to talk about companies really quick. When someone owns property in an LLC, corporation, whatever type of business entity, we need to figure out who has to sign. And that's not necessarily something you have to ask early on, but just so that you understand why we're asking. An LLC has what's called an operating agreement, or should, but sometimes when people set those up themselves, they don't know that that's something to create. That is not a standard form on the Secretary of State's website. But an operating agreement at its most basic level contains who the owners of that company are. We call those members. It also names a manager or managers, which is who can take action on behalf of that LLC. It has ownership interests. It has all the things. So when we see an LLC come up as the seller of a property, we're gonna ask, hey, can we see a copy of your operating agreement? That tells us who can sign. Pulling up the articles of organization, which is how an LLC gets set up with Secretary of State, does not tell us anything. It doesn't matter who the registered agent is. A registered agent is not a person authorized to sign on behalf of any type of company. A registered agent is the person or the entity that is named to receive legal process for a company. By legal process, I mean summons of a lawsuit, right? Summons to court, something like that, some other legal notice. A lot of folks think that registered agent means something other than what it does. So we're gonna ask you for an operating agreement for an LLC. We're gonna ask you for different documents for a corporation or other types of, there's also a laundry list of companies. And so that's why we're asking that question. We're also gonna have, in many cases, unless they already have something, they're gonna be signing a resolution where shareholders or members have to sign off on that action saying that it's authorized to sell property, authorized to buy property, authorized to take out $1 million loan, those sorts of things, so that we know they're actually authorized to sign the documents and that the company is actually authorized to take that action. Okay, just wanted to hit that quickly. Any questions about properties?
There is a term I was looking for, tax deferred exchange.
1031s. Yep. I personally decided not to go into 1031 snakes. That's a whole hour by itself.
Because no matter how many times I read it, Google try to break it down, it's something, how some things you just can't hit. Like that is something I just.
Yeah. Let me see if I can find you something that I think might be helpful to reading. Investor's title is a 1031 like kind of exchange coordinator. There has to be a third party involved to be the coordinator, and it's not an attorney. It's a different entity. And they're just one that we work with quite a bit. They have some information on their website about 1031s. So let me peek on that when I get back. And I'll try to email you some links, or I'll see if I have anything else that might be helpful. Oh, all right. Guys, we've been talking for almost 45 minutes. And I don't think I'm gonna get to go over this.
We go down rabbit holes. It's so
It's
self-help.
I love it. For sure.
It's self-help.
I do want to talk about earnest money. Okay. You probably all know that in a deal with financing, a buyer's earnest money has to be tracked. So generally speaking, the lender needs to see, they need to see where it came from, right? So that they don't think that they borrowed it from their best friend. So it needs to be a check or something. They want to see that coming out of an account. The thing I wanted to mention about earnest money is that we have to have a signed termination where both buyer and seller agree to the release of earnest money. That is not my rule. It is not any other attorney's rule in anywhere in North Carolina. It is something we have to have in order to release funds from our trust account. Okay, folks get really up in arms about it. Doesn't matter who we agree with. It doesn't matter who we think should have the earnest money. We have to comply with our rules, right? When a buyer and a seller don't agree, or you can't get one or the other to sign that termination agreement, there is a statutory process where we notify both parties that unless they agreement in days, we are going to place it on deposit clerk's office, and then they both have the option to file a proceeding in court to argue why they need or why they should get their earnest money back. They're the only way. We can't move any quicker than the 90 days, so we can't place it on deposit next week. We have to comply with the statute. Okay, I don't know if any of you have had clients who've gone through that, but happens quite a bit. Of course, the deal is terminating and somebody's mad.
Just so we're clear, in case anyone's into this, but in as long as it's been communicated to the other party that they intend to terminate even without it signed, or is doing one thing yes, this big house, and when it's communicated to you, you're able to put it back on the market as a selling agent,
Yes,
listing agent, even if there's a dispute with it. Correct.
yes, yes.
I just want to make sure with that.
Yes, and I'm aware that NCAR has a new termination form for you guys as well. I guess the new continues. Is, and I haven't seen it, so this is just an information I'm reading that it should make folks, even if they just, so if a seller disagrees with the reason a buyer is terminating, they can still agree to the release of the earnest money, even if they don't agree with the reason for the termination. They've separated that out somehow. So if you haven't seen that form, I've peeked at it. But maybe that will make it a little bit easier. And a lot of the time, folks don't want to wait 90 days. So once we tell them that, once we send them that notice, they'll work it out. They'll work out some split where they're like, whatever, take it. So just know that that is a process we all have to comply with. All right, here are your options for our last few minutes. We can either talk about the timeline for closings and disbursements, recording what attorneys do, why things take time.
Yes.
Or we can talk about other types of transactions. Leases with options to purchase, seller financing, contracts for deed vehicles.
Cards, like the other one.
Okay.
Great.
And I have okay, and actually I have a handout on that other one if you guys want it that explains the differences. There's a chart saying you don't deal with that stuff a lot, I know. But sometimes I do have an agent who comes to me, they've got a buyer who needs time for one reason or another to build credit, to make sure they want to live here, to make sure the job shakes out, whatever. And so we do have some other ways to get them into a house and to secure submission.
I think there's like so many more between for us that is probably a question that would have.
Yes,
I've given another part.
okay, so let's talk about timeline, right? This is obviously based on how things work in my office. But I've been doing this at least in it's been some portion of my practice in both my prior firm and my own firm now since 2006. And I also know in general, what the processes are for a lot of other firms. So just take this with a grain of salt. You don't work with us all the time. You work with somebody else. Like, well, that's not what they do. Totally fine. Just trying to like give you some information that may be helpful, right? So first of all, you get somebody under contract. We want that contract in order to open a file. I am occasionally contacted by an agent that's listing property, and for whatever reason, seller wants to check something. They want to make sure that everything's clear. They want to make sure a lien went away or whatever. Who needs to sign? So sometimes we do a sort of a free contract search, but that's obviously the exception, right? So we get the contract from you. We set up a file. In our office, we go ahead and order the title search immediately. Some firms do wait until a certain number of days or weeks prior to the closing date, and that's certainly fine. We like to order them early in case there's an issue, so that hopefully we have enough time to fix it, or to give notice to someone of what needs to be fixed, so that you've still got plenty of time to negotiate an extension. Title searches, that's us going through the records, through the chain of title to make sure someone has authority to sign, to see what needs need to be cleared. Sometimes we find, like right now, there's a open deed of trust from 1997. We're fairly certain it's paid off, but we've got to get it cleared. It's not old enough to have it insured over. And so we've got to get it cleared. That process typically takes at least several weeks. Once we get that title search back, we then are ordering what's called a title insurance commitment or title binder from a title insurance company. If your buyer has a lender, we have to have the lender's title request, which gives us the terms of their loan. So the amount, really just amounts and the mortgagee clause, because the lender is named as the additional insured on a title insurance policy. They require that so that they're protected if things go bad, right? So if something pops up after the fact, the lender wants to be insured against loss. Your buyer, in my office, they automatically get an owner's policy unless they sign a full harmless and indemnity agreement saying they don't want one and saying, yeah, I understand that you're telling me I should anyway. It is the most cost efficient thing that you could possibly do when you're investing in a home purchase. And we're talking, you know, it's just so inexpensive, so it always drives me nuts when people say they don't want it. There's also a new enhanced title insurance policy, which is just 20% more. That will insure over additional things that are normally accepted on a normal policy. That we're going to start using quite a bit on any properties that can be used on, can essentially be used on any platted subdivision, and lots of other things as well. But it gives survey coverage even when we don't want a survey. That's a big ticket item. So title insurance is really, really important. So when we prepare our opinion of title and give that to the title insurance company, most of the title insurance companies we work with are sending us that title commitment back, I would say within an hour, sometimes longer if there's something funky or volume, but we get it back pretty quickly. We then send that to the lender because that's something they need for underwriting. There are lots of things we do in that title searching process, right? So on a seller side in our office, we go ahead and do a current owner search. So just checking your seller so that we know up front what claims are against that and are asking them for the correct information about payoffs. Some folks who do seller side representation don't do a current owner search, and again, that's fine. We just always have. On the buyer side, we are either tagging to a prior insurance policy, prior title insurance policy, or we're doing a full search. Obviously, a current owner search, we can generally get through pretty quick. Unless the person has a ton of out speaking development or funky stuff to look at. We also check PwC assessments, city assessments. So those are all things we're checking as well. If you are working on a property and you know that there's an assessment, tell the closing attorney. It's just great information that you're already aware, because when we see it pop up, we're like, oh gosh, hope everybody is aware that this is there.
There's talking about that.
Right.
There's a spot on the top.
There is.
Yes, that's material back.
Yes.
Pull up the form that there's another firm I was at. They gave us a form that we as the agents could send to PwC. It's like an assessment.
Yeah, so there's an assessment form that we send into PwC where we list the basically identifying information about the property.
Right.
Yeah, I don't see why PwC would not return those to you guys as well.
I've done it a few times, but it was so long ago that I can't find that anywhere.
Yeah, I have it if you want it. Yeah, not at all. We do get those back pretty quickly. So anytime that you want to know, so we do the PwC request when we open the file certificate. That's day 1 or day 2 when it's going to PwC. I would say for the large majority, it goes back within 24 hours. So if you want us to check something, yeah, okay. Also, I mentioned mobile homes here really quick. They're a nightmare. Ask any closing attorney. If you know it's a mobile home or a manufactured home, again, we'd love to know that. Sometimes there's nothing to let us know that. If it's already been converted to real estate, or you think it's been converted to real estate, there may not be something to tip us off to it. If it hasn't, then in a perfect world, we'd love to get a photo of the data plate. That's what we need to run it with DMV, or sometimes there's other things we need to do to run a HUD label. I've got one that we've been working on for 6 months, and numbers don't match, owners don't match, and now we think it might have been purchased in Florida. So, they, that's the exception. We deal with a lot of them, and those are mostly on existing, right? So it's from 20 years back, and we're trying to track information. That the buyer, for whatever reason, also won't call me back, which I don't really understand, but if he would just let me go to the house and take a picture, then maybe I can get it up. So, but anyway, just know that sometimes we do need that, and that's the best way for us to find to get the true serial number. We can generally find that information. Obviously, there's a data plate at the end of the mode. Also, typically we see those in electrical panel or a cabinet. So those are places for you to look for that if you can when you are listing property. Closing. So you are going to typically find out from the lender, from your buyer, that something is clear to close. You're going to call your closing attorney and get that on the schedule. You can certainly schedule closing several weeks out based on that contract date, but as you and I both know, that rarely sticks. It's going to move in one direction or the other. And sometimes I think the back and forth of that is more frustrating to our mutual client than helpful, because they really get set that they're going to close on that date. So I think when they get that 3-day disclosure, that's a great time to schedule it. Let's talk really quick about POAs. If you have a buyer that's elsewhere, some of the agent who asked me a couple of days ago, do I think a mail away closing is better or a POA closing? Mail away being where we ship the package to them or we email it to them. We email it to them, they have to print it. Either way, they have to sign all of it in front of a notary and send it back to us. Folks have a really hard time doing that directly. They do. You got to remember, they don't do this every day. So if they're sitting in front of me and I'm saying, I need you to sign here, an initial here, and date here, and you've got to sign your name this way, X, Y, Z, then it seems really easy, right? When somebody sits down with a 50-page closing packet, it is completely overwhelming, right? And how often do you walk into a closing and they go, oh my God, I've got to see all of that? So mail-aways are great. I'm certainly not trying to talk you out of them, but I guess I'm suggesting think about your buyer, and do you think that they're going to be comfortable in that process? I've also Zoomed with folks before signing a package. I actually did that when I COVID. But it at least walks them through it. You can get on the phone with them or whatever. With a POA, just keep in mind that a POA still has to be signed by that buyer or seller that's elsewhere. So sometimes someone will come to us and they're like, hey, my seller needs a POA. That may totally make sense if you just got the property under contract, or maybe you're just listing it and they're getting ready to leave next week. If we can just go ahead and get them to sign seller docs, hold those though, sometimes that's easier. Right? Because either way, signing a POA or seller docs, they've got to be signed and notarized, originals come back to us. So just keep that in mind. POAs can be great, but they require some effort as well in the original.
Do you have a minimum on like if they have cash to close? I know some attorneys, if it's like $1,000 or be a personal check, but anything more than that has to be in like bank check and stuff. Is that what's yours?
Yeah, so typically I say $250 or less.
$250.
Yep.
Okay.
Certainly if it's an agent I've worked with for a long time, I'll absolutely waive that. Otherwise, we accept cashier's checks, money orders, and wires.
Yeah.
Some firms will only do wires, or everybody kind of has their own relationship just because of the accounting stuff that we have to do, the reconciliation side, and the risk for fraud. So just want to check with.
Is cash a no-go?
Cash is okay, but if you bring me $10,000 or more in cash, it's a special reporting thing that I have to do. And to be perfectly honest, we'd rather not receive much cash, because I feel like I've got to get it to the bank right then. Right. All right. Helps if your folks will deal with that. They will wire or get your cashier's checks day before if you get a CD early enough. I get it, but sometimes you don't. If they need to go do it that morning before they're closing, that's great. But if they have a 10 o'clock closing, please tell them not to be at the bank at 9:30. So they're not gonna make it. It's okay for them to go after closing. Obviously, we've got to have it before we can move forward with reporting. And I'll just make sure they understand that. There's also kind of a misconception that wires are immediate. They are not. Right? It leaves someone's account, it goes to, it hits the Federal Reserve, then it hits the bank for your closing attorney, and then it gets credited to that account. Sometimes that does happen really, really fast. But sometimes it can take several hours. So wires are not immediate. E-reporting is not immediate. Some counties are really fast. Wake County, for example, is typically under an hour, so is Harnett County. Cumberland County, I always say, is 2 to 4. Hope County, I would say, is typically 2 to 4, but they have just a smaller staff, so they can get a little all over the place. Robinson County is all over the place. I don't know what to tell you as an average. So just keep that in mind with the counties that you deal with. More counties pretty quick. Anyway, but people think they always, well, you report, right? But that's not right. So we upload the documents in our office through a third-party portal. They are then sent to the county where the reporting actually takes place. They pull it from the portal. They do what they need to do. They send it back through that third party, and the third party notifies us that it's reported. So sometimes if you're sitting there clicking refresh on registered deeds, you'll see it before we do. There's typically about a 30-minute lag. But just make sure that your folks understand that reporting is not immediate. And checks don't magically print from our printers once reporting is. We actually have to go in to the file and do some things to print checks. We really strive to disperse the file within an hour of reporting. That's not going to happen all the time, of course, depending on what's shaking that day. But particularly on a Friday, we ask our agents to schedule their stuff early so that we can attempt to get it recorded in dispersing day. If you can convince your buyer to not close Friday morning with the intent to move in Friday afternoon, I will buy you your favorite cocktail. Like I'd much rather stay late on a Thursday, even if they need a late afternoon, or I even do evening or early morning appointments sometimes to accommodate someone's work schedule. But too often it's the couple buying a house, their 3 kids and 2 cats, a dog, and she's pregnant and she's giving birth next week, right? And then you call it. So let's not do that. Those are the things that make us drink wine. So that is the majority of my piece of paper. Great. Thank you for having me. And if y'all have questions, feel free to yell.
So if I email you, this is so the first about getting these phone on my feed. This is like eating around.
Just yes.
Just email you and
Text or
text.
email me, yes.
What do you need from me?
To what?
What do you need from me? My address.
Just the address, how you want your name listed. That's probably.
Thank you. I'm not feeling that. Like that sounds like a nightmare. Like I'm to the point now. Like it's beautiful. I realize I'm not gonna live forever. Like I thought I was 30. You know what I mean? And so, like I put this place. My husband and I got life insurance 2 years ago. We had a staff was like. He's like, how much am I worth to you? I'm like, all right. What should happen? This or not. So, alright, I'm gonna email you right now. I got you there. Oh.